Malamig lang. Pumasok na. Wala namang pipindutin, ha? Paano ko malaman kapag may ano na? Hindi pumasok. Wala pa na. Binuksan ko na. Dalawa na, mami. Di pa? Wala pa. Walang 5. Konti pa lang yung ano. Yung electric pan siguro dyan. Nainita lang. Mahina sa kabila. Wala pa lang 5 o'clock eh.
Hindi ko kasi yung medyas mo.
Ito na yun. Hindi ba madilim, mami? Tingnan mo na. Ayan. Patay mo ito isa.
Hindi, open na yan lahat. Madilim pa.
Kasi ano. Marami na. Tingnan mo.
45 pa na.
45 pa lang. Saka may 1 minute pa. Wala pang 5 lang. Wala pang 5 o'clock. 1 minute pa. Wala pang 5, 1 minute pa. Okay, your lecturer is now on board. Welcome to the second series of bar lectures. Future compañeros and compañeras, although there are lawyers, prosecutors, and judges who joined us, no? Yesterday, there were lawyers, judges, and prosecutors that were my friend also joined us in our political law review, bar review. Now, My second topic is about international law. This is my favorite subject in MCLE. I lectured international law 10 times in MCLE. So lawyers, judges, justices always ask about treaty. No, they always ask me treaty, whether or not the president can unilaterally abrogate a treaty. We will discuss it. No? So my topic today is about public international law. So always, I will give you first the entire backbone or bird's eye view of international law, wherein I believe it will come out in the bar examination, and that it will help you a lot in passing or topping the bar examination. Like last year, my student topped the bar number 2. So I produced so many bar top notchers, no? Hopefully that some of you will become bar top notchers. I produce so many bar top notchers. So I will just give you the entire backbone of my lectures on international, wherein I believe it will come out in the bar. So always ask in the bar, is international law a true law or not? If it will be asked again in the bar, what will be your answer? Is a public international law is a true law or it is not a true law? There are two theories here. No? We'll discuss this later on. No? Then another one, in case of conflict between international law and municipal law, what law will prevail? Is it municipal law will prevail over international law, or international will prevail over municipal law? So, and what was and how the Supreme Court applied the two laws, no? Whether it is municipal law or international law. So we discussed the 3 leading cases here. The case of Ichong versus Hernandez, wherein a treaty or an international law is in conflict with municipal law. Then we also discussed the case of Gonzales versus Echanova, wherein another international law is in conflict of municipal law. And the last one in the case of Garcia. So these 3 are the landmark decision. If there is conflict between municipal law and international law is superior over municipal law, or it is the municipal law superior over international law. And there are 3 leading cases here. No? The case of Ichong versus Hernandez, the case of Gonzales versus Istanova, and the case of Garcia. We'll discuss it extensively. Then we will proceed with the monist theory and the dualist theory. No? So there are 2 theories here, no? The monist theory and the dualist theory. So which of the theories our own Supreme Court applied in case of conflict between municipal law and international law? Is it the monist theory or it is the dualist theory? Then I will discuss it in the case of Philip Morris Incorporated versus Court of Appeals, and in the case of United States of America versus Ruiz, and Lyson versus United States of America. So we'll discuss what theory our own Supreme Court applies. It is the monist theory or it is the dualist theory. No? We discuss it in case of conflict between international law and municipal law, who will prevail. There are so many leading cases here. No? Also, the Holy See. No? The case of the Holy See versus Executive Secretary De Rosario, wherein it was asked who will prevail, no? Municipal law or international law. Then we will proceed with after the monist and the dualist theory. We will also discuss the state sovereignty. No? So what is state sovereignty? You know, I discussed yesterday in political law that the state is immune from suit You cannot sue a state. How about if the state sue another state? For instance, Philippines will sue US, or US will sue Japan. Then is Japan suable, or can we sue the government of the United States of America? So this is the doctrine of state sovereignty. We will discuss it, whether or not we can sue another state, no, under the doctrine of sovereignty. Then we proceed with jurisdiction. No? You know, jurisdiction under our municipal law, especially on the remedial law, jurisdiction is the authority of to act, to try, to hear, and decide cases. No? So, but under international law, the definition of jurisdiction is different from our municipal law. No? It is the law that it will try, hear, and decide cases. But under international jurisdiction says that the state have jurisdiction to its citizens or persons and things within its territorial boundaries. So it is different, the jurisdiction under international law and jurisdiction under our municipal law. I will discuss it extensively, especially on cases of nationalist theory and the link theory, no, wherein it might come out in the bar examination. Then, when I lectured international law, last bar examination, I told my students, you study the double criminality doctrine. It will come out in the bar. I said to them, watch out! The double criminality theory. Then, it was us in the bar. Sir, 100% it come out in the bar. So I said, you better study the doctrine of double criminality. Yes, it come out in the bar examination. That is why they were so very happy that 85 to 90% of my forecast in the bar examination, that's political law and international, came out in the bar examination. Then, after that, we will discuss also sources of an international law. There are two kinds of sources of international law. One is the primary sources and secondary sources. Then we proceed with the very important provision of the law, the law on the seas. No? Especially, I discussed it last bar examination. I told my students, the barristers, that 100% it will come out in the bar examination, the law of the sea, especially on the 200 nautical miles exclusive economic zone. And I said, it will come out in the bar. Yes, it come out in the bar examination. Again, I believe it will come out again in this bar examination. So the exclusive economic zone, that is 200 nautical miles, under the United Nations on the law of the sea. That is very, very important. Why? Because, you know, the Chinese, although they don't own that the 200 nautical miles in the West Philippine Sea, they conducted a scientific survey, a maritime survey, they constructed an artificial buildings there. So they are not allowed. Why? It is under our exclusive economic zone. 100% again, it will come out in the bar examination. The exclusive economic zone, that is 200 nautical miles, because so I believe it will come out in the bar. Can the Philippines and Chinese can have a joint exploration, scientific exploration on the West Philippine Sea? The answer is yes. But how about the percentage? So because we own the 200 nautical miles exclusive economic zone, it should be 60-40. No, if you have no money, so we discuss it. We also discuss what is an international sea and what is a high seas, no? Because it is favorite question in the bar. What is an international sea or high seas and territorial sea? You remember our archipelagic doctrine in our territory, archipelago doctrine, no? So, remember that it will come out definitely in your bar examination. So, another one, I told my students last bar examination, study the doctrine of innocent passage. It might come out in the bar examination. The doctrine of innocent passage, no? Because there are so many foreign vessel pass under our territorial sea. So, if there is what we call the doctrine of innocent passage, so I will discuss it extensively, the doctrine of innocent passage. Then, another very important provision in international law, because I codified, I give you a brief, concise of all international law. You know, future compañeros and compañeras, although there are lawyers, judges, and prosecutors who also joined our online bar review. You know, when I lectured before judges, prosecutors, and lawyers about international law, they always we always discuss, they always ask questions on extradition treaty and whether or not the president can unilaterally revoke, abrogate, terminate, invalidate our treaty. I will discuss it extensively, although the case is still pending in the Supreme Court. I told the lawyers, the judges, you can ask questions under the sun, even about international law, because I'm also an expert in international law. So, we will discuss it extensively. We will discuss what is an asylum. Is asylum the same with deportation? Is deportation the same with extradition? No? So because there was Inan, no, who always joined the rally against Duterte, no. So she was deported. No? So is deportation same with extradition? The answer is no. So we discuss extensively the meaning of deportation. Deportation, alien or foreigner can be deported because they are committed a persona non grata. No, they have a bad behavior, like the Chinese who spit on our immigration officer. They were deported. No, you are a persona non grata, bad behavior. We can unilaterally deport any foreigner because it is a unilateral act of a state. But how about extradition treaty? If you want to be extradited, for instance, a Filipino committed, there is a what we call the latest case in international law. A Filipina made in Hong Kong was murdered by a foreigner, no, who is a husband and wife. One is a Lebanese. I don't know who is the Lebanese and Syrian couple. So they murdered. They put it inside the refrigerator. So then they escaped. They went back to Lebanon. Then the Hong Kong police found out that the Filipino was murdered. So the Hong Kong government asked the Lebanon government and Syrian government to extradite the foreign couples who committed a crime under their law. Likewise, Philippines, we also ask that they will be also extradited because under the doctrine of jurisdiction, under international law, we will protect our citizens, whether within our territory or outside our territory. So we ask also, but they do not want to extradite. So if there is no because there is no extradition treaty, so what will be the best remedy? The best remedy is to apply the international customary law. International customary law is the best procedure to extradite if there is no extradition treaty. I will discuss extensively the international customary law. That is the best. If there is no extradition treaty. An extradition treaty is either bilateral or multilateral. No? So I will discuss. It is very, very important. The concept of international customary law. No? How about asylum? What do you mean by an asylum? No? So, for instance, when I received so many death threats, I was ambushed 7 times, and they put bombs on my car. No, so I went to the U.S. No, can I seek asylum? Yes, if you are persecuted. No, so we will discuss what is an asylum, what is an extradition, what is deportation. No, we discuss it extensively. So next, what is a treaty and what is an executive agreement? So there is now a pending case in the Supreme Court whether or not, and the question there in the Supreme Court now is that whether or not an executive agreement needs ratification to Congress. The answer is no. If it is an executive agreement entered by the head of state, it is not subject to ratification by Congress. Now, because if it is a treaty, it must be ratified by Congress, not the lower house, but only the upper house, the Senate, with a 2/3 vote. Remember, no, I will discuss it extensively. I will explain it extensively. Why an executive order no need to be ratified, but in a treaty there must be a ratification by Congress. So many lawyers, when I lectured international law, they ask me, Judge, you are an expert in international law. My question is can the president unilaterally abrogate, terminate, invalidate, withdraw a treaty? They ask me questions. They are all legal luminaries. Now, Judge, you are a constitutionalist. You are an expert in international law. What is your answer? So I will discuss it now. I said to them, compañeros, compañeras, judges, justices, remember, in treaty, it must be ratified by Congress or by the Senate. So, if the President will abrogate, terminate, invalidate, withdraw a treaty, then I believe it must also be ratified by the Senate or Congress. We will discuss it extensively. Then my last topic in international law is the law on war. So, pag may gera, what are the laws to be applicable? So, that is the backbone of my entire lectures on public international law that I believe it will come out in the bar examination. But it's better you have to attend my pre-week lecture because I will make a forecast international law together with political law. So, future compañeros, compañeras, and compañeras who are now listening to my lecture, I will now proceed with the first topic. Always asked in the bar, is international law a true law or not? So, if it will be asked in the bar, what will be your answer? So, always ask in the bar, is public international law a true law or it is not a true law? And second question that I always ask in the bar, if there is conflict between municipal law and international law, what law will prevail? Is international law supreme over municipal law, or it is the municipal law supreme over the international law? we will discuss the three leading cases, landmark decision of the Supreme Court. Number one, the case of Ichong versus Hernandez. Second, the case of Gonzales versus Echanova. And the third one, the case of Garcia. They are very, very important provision on public international law. So, if it will be asked again, is international law a true law? You have to qualify your answer. The answer must be, by conventional criteria, international law may not qualify as a true law. Why? Under conventional criteria, international law is not a true law because it is not promulgated by superior authorities and no penalties are formally prescribed for its violation. So remember, under the conventional criteria, international law does not qualify as a true law. Why? It is not promulgated by a superior authority and there is no penalties formally prescribed for its violation. However, so you must qualify. However, international law will also be considered as a true law because it has an obligatory force and effect under the doctrine of use cogens. So under the use cogens, customarily the international law becomes a true law. No? So there are two criteria here. No? So if you will, if it will be asked again in the bar, your answer must be yes. It is a true law under the conventional criteria. Then you discuss why. Then yes, it is not a true law under conventional criteria because it is not promulgated by a superior authority. No penalties are formally prescribed. So it is not a true law. However, under the use cogens principle, it may be considered as a true law. So that will be your answer in the bar examination if it will be asked whether or not international law is a true law or not. So qualify your answer. Okay, we now proceed with always asked in the bar. In case of conflict between municipal law and public international law, what law will prevail? Is it municipal law or is it international law? So, we discuss first the case of Ichong versus Hernandez. Now, in this case, in the case of Ichong versus Hernandez, there was a treaty entered between the Philippines and China, wherein foreigner can have business in the Philippines on rice, but there was a rice tarification law. So there's now a conflict between municipal law and international law. Ichong said international law is supreme over the tarification law on rice. But how the Supreme Court decided? Likewise, in the case of Gonzales versus Echanova, 9 Iskra, page 250. In Ichong is versus Hernandez is 101, Philippines, page 1055. And in Gonzales, it is 9 Iskra, page 250. And in Garcia case, 2 Iskra, page 984. So, how the Supreme Court decide? In case of conflict between municipal law and public international law, the prevailing law will prevail upon the tribunal to which the question is raised. From the viewpoint of municipal tribunals, however, when there is a irreconcilable and no choice have to be made between international law and municipal law, the local court should uphold the municipal law. So, in these cases, in the case of Ichong versus Hernandez, Gonzales versus Echanova, in the case of Garcia, the Supreme Court ruled that municipal law and international law are equal. But if there is really a conflict between the two, then judges should decide in favor of our municipal law. That is the case of Ichong versus Hernandez, the case of Gonzales versus Echanova, and the case of Garcia. Because according to some legal commentaries, the courts are organs of the municipal law and accordingly bound by its circumstances. The fact that international law has been made part of the municipal law in municipal sphere, that is the doctrine of incorporation as applied in the most countries, degrees, and rule of international law. So, according to the ruling, the courts, if there is really a conflict between municipal law and international law, the court should decide in favor of municipal law because courts are organs of municipal laws. But in succeeding cases, so that is the decision. No? But always the Supreme Court ruled that there is Mami, natutumba.
Okay. Okay na.
Okay na. Hindi natutumba siya.
Okay.
Yan o.
Jesus.
Ipet. Ayun o, wala.
Ay, naku. Saan na yan?
Ayan. Baba, ibaba.
Ayan naman na lang. Ganun.
Ibaba. Uy.
Balik. Okay na yun. Kasi na yun. Okay na yun.
Lagyan mo na ng bibro. I'm sorry that there is a problem. Huwag kamay niyan. Hindi ako makita. Ganun lang kaya. Bakit maluwag yan? Di ba pwedeng ikita?
Kita muna. Kasi dito. Ay. Okay.
Okay na.
Wag mo nang galawin kasi.
Okay? I'm sorry, future compañeros, na there is something happened in my the stand of my cell phone. No? So we now discuss the munis and the dualist theory in international law. So the munis theory and the dualist theory of international law. Then always ask in the bar, what do you mean by a monist theory and what do you mean by a dualist theory? And that what theory the Supreme Court applied, it is the monist theory or the dualist theory. So we'll discuss now what is a monist theory. So, and what theory our own Supreme Court applied, monist theory or the dualist theory? Monist theory believes that international law and domestic law are part of a single legal order. International law is automatically incorporated into each nation's legal system and that international law is supreme over domestic law. So in monist theory, international law is supreme over domestic law. Monism requires that domestic law give effect to international law, notwithstanding consistent domestic law, even the Constitution. So under the monist theory, international law is supreme over domestic laws or municipal laws. So that is the monist theory. Then we'll discuss the dualist theory. Then what theory our own Supreme Court applied in cases. How about dualist theory? What do you mean by dualist theory? Dualist theory. Dualist theory contend that international law and domestic law are distinct and each nation ascertaining of itself as to what extent international law is incorporated into its legal system. So in this case, in the dualist theory, international law and domestic law are distinct each other. No? They are same. No? There is no superiority among them. So under this view, when a municipal law provides that international law applies in whole or in part within our jurisdiction, but an exercise of authority of municipal law, then adoption or transformation of the rules of international law. So in monist theory, that they say that international law is supreme over municipal laws or domestic laws. But in dualist theory, no, they are equal. No? But in case of conflict, municipal law will prevail over international law. Okay. In the case, I will discuss the case of Philip Morris Incorporated versus Court of Appeals. 224 Skra, page 567 up to 593. The Supreme Court, in this case, ruled that international law had been made part of the law of the land, does not by any means imply the supremacy of international law over the doctrine of incorporation. So, the international law is not supreme over national law. Under this doctrine applied, no? So, they are not, international law is not equal, but it's not superior, but they are equal. But in case of conflict between international law and municipal law, then we courts should decide in favor of municipal laws. So that is the case of Philip Morris Incorporated versus Court of Appeals. Okay, we now discussed the primary sources and secondary sources of international law. International law. Sometimes it is asked in the bar, no? It was asked in 2003 bar examination. What are the primary sources and secondary sources of international law? So if it will be asked in the bar, what will be your answer? So the answer is under the Article 38 of the Statute of International Court of Justice. So Article 38 of the Statute of International Court of Justice, the primary sources of international law are as follows. Number one, International Convention. That is the primary sources of international law. Vienna Convention of the Law of Treatise. International Customs. Prohibition against slavery. Prohibition against torture. The general principles recognized under civilized society, and you still remember, Pacta sunt servanda, prescription and due process. So you still remember, Pacta sunt servanda, saka rebus sic instantibus. You still remember, rebus sic instantibus. No? Wherein that is one of the grounds for termination, abrogation, invalidation of a valid treaty. So, those are the primary sources of international law under Article 38 of International Court of Justice. International Convention, Vienna Convention of the Law of the Sea, international customs, provisions, so on and so forth, and other general principles of law. How about secondary sources of international law? So, the following are secondary sources of international law. Judicial decisions. So, judicial decisions, teachings of highly qualified various nations and human rights. Now, those are the subsidiary sources of international law. So, you just study the primary sources of international law and the secondary sources of international law. We will now proceed with sovereign immunity, always asked in the bar examination in political law. So, sovereign immunity. We discussed yesterday that the state cannot be sued without its consent. It can only be sued if there is a express consent through a general law. What is the general law? Act number 3083, or a special law. What is the special law? Cumulative Act 327 as amended by PD 1445. Those are the law wherein it expressly provides for suit, no? Meaning to say that there is an express consent that the government or the state can be sued. How about sovereign immunity? Can one state sue another state? So, for instance, Philippines will file a case against U.S. or U.S. will file a case against Japan, or Japan will file a case against China, or Philippines will file a case against China. So, is the state immune from suit under the doctrine of sovereign immunity? If it will be asked in the bar examination, what will be your answer? So, under Article 16, Section 3 of our Constitution, it says that the government is immune from suit. The principle is based on the very essence of sovereignty, on practical ground that there can be no legal right against authority that makes law. The rights depend. So that is why the principle of sovereign immunity, that the essence is that no legal right against the authority that makes the law. That is the answer. So, in the case of United States of America versus Ginto, 182 scrap, page 644, the state, in the decision of Supreme Court, the Supreme Court ruled, the state consent may be given either expressly or impliedly. Express consent may be made through a general law, no? That is Act 3083, or a special law, that is Cumulative Act 227 as amended by Presidential Decree number 1445, no? The general law way being, no? That is wherein the government consent that it can be sued provided that you have to file it, the money claim, before the Commission on Appointment. That is the case of United States of America versus Ginto. So the state, although a sovereign state cannot be sued, but if it is expressly, there is a law, there is express consent or implied consent, then it can be sued. I told the barristers last bar examination that 100% it will come out in the bar examination. Yes, it come out in the bar examination. So it come out in the bar examination wherein the U.S. Embassy hired a contractor to renovate the U.S. Embassy. Then there was a termination of contract. Then the contractor filed a case against the U.S. Embassy or the United States of America. Then said, no, we are immune from suit under the doctrine of sovereign immunity. The Supreme Court ruled, no, there is an implied waiver. Once the state enters into a contract, then there is an implied waiver. They can be sued. That is the case of United States of America versus Ginto, 182 scrap, page 644. Likewise, in the case of Freeland versus Pan Oriental Shipping, GR number 6060, then another one is the case of Lyons versus United States of America, 104 scrap, page 593. The Supreme Court ruled that if there is consent, then they are liable. Implied consent, according to the Supreme Court, in the case of Freeland versus Pan Oriental Shipping, and in the case of Lyons versus United States of America, the Supreme Court said implied consent when the state itself commences litigation. So if you're the one who filed first a case, if the state, then it can open to counterclaim. Or if enters into contracts, then there is an implied consent. So, sovereign immunity is no longer applicable because there is a implied consent. So, future compañeros and compañeras and lawyers, judges, I saw the message of Judge Tony Olivete, my former PAW lawyer who is now the executive judge of Taguig RTC, thank you, Judge, for listening my lecture. So, you remember those cases now that under the doctrine of sovereign immunity, they can still be as a general, they cannot be sued. But except there is an express consent, then implied consent. Under our law, what is the express consent? General law. What is the general law? Act number 3083. What is the special law? Commonwealth Act number 227 as amended by Presidential Decree number 1445. So remember the case of U.S. versus Ginto, Portland versus Pan Oriental Pacific, then the case of Lyons versus United States of America about implied and express consent. Then we proceed with the theory on sovereign immunity. There are two theories here. One theory is the restrictive theory or the newer theory. Another one is the classical or absolute theory. So, under this theory, we'll discuss whether or not a sovereign state can be sued. So, there are two theories here. The restrictive theory, or we call it newer theory, or the absolute or classical theory under international law. So under restrictive theory, wherein the Supreme Court ruled in the case of Holy See versus Honorable Edelberto Rosario, 238 Iskra, page 542. So in this case, the Supreme Court defines the meaning of restrictive theory. According to Supreme Court, restrictive theory came about because of the entry of sovereign states into purely commercial activities, remotely connected with the discharge of governmental functions. Certainly, the mere entertaining into a contract by foreign state can only be start of an inquiry. Logically, is the foreign state now engaged in a regular course of business. Therefore, it can be sued. But in the case of Holy See, whether or not the Pope of Rome can be sued, because there was a case filed to the Pope, the Holy See. The question is whether or not diplomatic immunity given by the government to the Pope or the Holy See, they call it Holy See, the Pope, is a political question. The Supreme Court ruled in the case of Holy See versus Edelberto Rosario, the Executive Secretary, 238 Iskra 542. The Supreme Court ruled the issue whether a person or entity is entitled to diplomatic immunity is a political question, and such determination by the executive branch is conclusive on the court. So it is conclusive on the court. Therefore, it is a political question. Yesterday, I discussed political questions and judicial question. So if it is a judicial question, then it is the court can act on it. But if it is a political question, it is the wisdom of another department, then it is a political question, then we have no jurisdiction. That is the case of Holy See versus Executive Secretary Edelberto Rosario, 238 Iskra, page 542. Okay, so we now proceed with other topic. Diplomatic and consular immunity. Are diplomats our consul general, consuls are immune from immune from suit, no? Whether it is criminal case or a civil case. So always ask in the bar. It was asked in the 1995 bar examination whether or not a diplomat or a consular is immune from suit, whether it is civil or criminal. So what is your answer if it will be asked in the bar? So the best answer is that you quote Article 32 of the Vienna Convention on Diplomatic Relations, on diplomatic agents. No? So it said that as a general rule, the diplomat enjoyed immunity from criminal jurisdiction of a receiving state. Also, they are exempted from civil and administrative jurisdiction, but there is an exception to the rule. Number one, according to the Article 32 of the Vienna Convention on Diplomatic Relations, as a general rule, diplomats and consular officers are immune from suit, whether criminal, civil, and administrative, except the following: if involves real property, no, wherein the buy real property, then it is not because it is a civil case. No, then if the diplomat is an executor, administrator, or heir or legatee, then he can be sued. So because it is not in the performance of their duties, he buy property, then he can be sued because that is not a functions of a diplomat or a consular officer. But as a general rule, under Article 32 of the Vienna Convention of Diplomatic Relations, they are immune from suit, the diplomats and consular officers. So remember Article 32 of the Vienna Convention of Diplomatic Relations. Okay, they are also liable if it also they enter into contracts. No, if they enter into contracts, then they are liable. Also, they have an accident. No, they drive a car, an accident, then they are also liable. But as general rule, they are not liable. So under international law, diplomats and consular officers are immune from suit, but except if they enter into contracts, except they buy properties, except they performs outside their functions, then diplomatic functions, then they are not immune from suit. We now proceed with jurisdiction. As I've said, jurisdiction under international law is different from jurisdiction under our domestic law. Under our law, jurisdiction is an authority of the court to try, hear, and decide cases. Now, that is the meaning of jurisdiction under our law. Jurisdiction is the authority of the court to try, hear, and decide cases. But under international law, what is jurisdiction? Under international law, jurisdiction is often defined as the right of the state to exercise authority over a person or things within its boundaries, subject to certain exceptions. So, under international law, jurisdiction is often defined as the right of the state to exercise authority over its citizens and properties within its boundaries, but subject to an exception. The state does not assume jurisdiction over traveling foreigners, but the state does not assume jurisdiction over traveling sovereigns, ambassadors, and diplomatic representatives. No, they are not. So that is the case of HSBC Chairman, GR number 72494, August 11, 1987, decision of the Supreme Court. In this case, the Supreme Court ruled the state is competent to take hold in a judicial manner its feet by making its courts and agencies assume jurisdiction over all kinds of cases brought before them. So, international law, jurisdiction under international law is defined as the right of the state to exercise authority over its citizens and things or properties within its boundary, subject to exception. Next, what do you mean by protected principle of jurisdiction? It was asked in the 1991 bar examination. If it will be asked again in the bar, what is a protected principle of jurisdiction? What will be your answer? The answer will be, under that principle, any state has the right to punish acts even committed outside its territory. So under this principle, the state can punish acts committed even outside of our territory. No? So what are those? No? Terrorism. No? Try to destroy the government. No? Falsification of money stamps, seals, and official seals. No? So even you are outside the Philippines, for instance, you are in the U.S., then the state, under this doctrine, our government, the Philippines, have jurisdiction over you. So if we have extradition treaty to the U.S., then you can be extradited, because under this principle, the state have the right to punish acts even if committed outside its territory, when such acts constitute an attack against its, number one, security, like terrorism, falsification of money, stamps, seal, or official marks. So, although as a general rule, it should be within our boundary, but this is an exception to the rule. Now, the state can still punish acts committed outside its territory. So remember the case. Citing an amjur, U.S. versus UNES. This is a Philippine jurisdiction. United States of America versus UNES, 189 iskra. So remember the case. Okay, next. What do you mean by nationality doctrine? So, if it will be asked in the bar, what will be your answer? So under nationality doctrine, a state may exercise jurisdiction over its national with respect to their conduct, whether within or outside its territory, insofar as the rights of under international law as regards rights of the states. So that is the case now. Under the national doctrine, a state may exercise jurisdiction over its national, whether they are outside or within our territory. So that is the doctrine of nationality, the doctrine of nationality. How about the doctrine of effective nationality link doctrine? So for instance, if you have double or triple or multiple nationality, like my grandson have 3 nationality. He is a Filipino, natural born Filipino, because his father is my son. He is also a Russian national, because his mother is a Russian. Then he's also a natural born American citizen, because he was born in New York City. So he have 3 nationality. So under the effective nationality link doctrine, for instance, if my grandson committed a crime, what state will protect him? Because under the doctrine of nationality jurisdiction, every state have jurisdiction over its national, whether outside its territory or inside its territory. So there are 3. The U.S. government can protect him, the Russian government can protect my grandson, and the Philippine government will also protect my grandson. That is the effective nationality link doctrine. So in this case, it is used to determine which of the 2 or 3 states a person is national, will be recognized having the right to give diplomatic protection to the holder of dual nationality. So it involves about dual or multiple nationality. So you study the effective nationality link doctrine if you have a dual or multiple nationality doctrine. So whoever state will give a protection because that is a because under international law jurisdiction is to the persons or things outside or inside or outside the boundaries of the state. So remember the nationality doctrine, remember the effective nationality link doctrine. In effective nationality link doctrine, it involves two or multiple nationality. So remember that. Future compañeros and compañeras, also our judges and prosecutors and lawyers who attended my lecture. I will now discuss the very, very important topic in international law. International customary law and extradition treaty. So, what is an international customary law? And what is an extradition treaty? So, we have a concrete example of a case under international customary law and under extradition treaty. The case of a Filipina maid was murdered in Hong Kong. Then the foreigner spouses escaped and hid in Syria and Lebanon. So under the doctrine of jurisdiction, we have to protect our nationality. So the Philippine government asked the Syrian government and the Lebanese government to extradite the spouses because they killed and murdered a Filipina. Likewise, the Hong Kong government requested the Lebanese government and the Syrian government to extradite their citizen in order that they will face the murder cases committed to a Filipina domestic helper. Libyan government, Lebanese government and Syrian government denied because according to them, Hong Kong have no extradition treaty to Syria and Lebanon. Likewise, Philippines have no extradition treaty to Lebanon and Syria. So, what will be the law we will use? We will use the international customary law. Remember, future compañeros, it might be asked in the bar, international customary law. In the absence of a treaty, then we can request to extradite that murderer to the Philippines under international customary law, not under a treaty because we have no extradition treaty. So what is an international customary law? So you study carefully because I believe it will come out in the bar examination, international customary law. So international customary law, in its name suggests, it is created by custom. It is one of two created either by evolution that can be traced early development of global society wherein there is an international law. No? So then it is legally binding among the different states. No? So international customary law is a law, a principle of international law. No? It is a request to the another state to extradite their national and to bring their national to the Philippines to face the cases filed. No? Because Hong Kong also used international customary law requesting Lebanese government, requesting Syrian government to extradite the spouses. Philippines also use international customary law. When we use international customary law, the government of Lebanese and the government of Syria said we cannot extradite them because we will try them under our criminal law. So they said, we cannot extradite them under international customary law because they also violated their law, a criminal law. They killed a Filipina domestic helper. So they tried in Syria, they tried in Lebanon. So that is there. So remember, no, the international customary law, that if there is no extradition treaty, then we can use international customary law. There are two essential requisites in international customary law. Number one, a general practice of a sovereign state. Second, the acceptance of the state for this general practice as a law. No? So there are two requirements in international customary law: general practice of a sovereign state and the acceptance of the state of this general practice of law. Remember, future compañeros and compañeras, it will come out in the bar international customary law because of our case of a Filipino domestic helper murdered in Hong Kong, but the employer escaped in Lebanon because one of the spouse is a Lebanese, one of the spouse is a Syrian. So remember, international customary law. So, we now discuss asylum, very important topic. We discuss asylum, we will discuss deportation, and we will discuss extradition. Is asylum the same with deportation? Is deportation the same with extradition? The answer is no. In asylum, you seek an asylum in another state because you are prosecuted or persecuted. So, like Ninoy Aquino, have an asylum in the U.S. How about deportation? Deportation is a unilateral act of a state to deport a foreigner because he is committed a bad precedent. No? He is considered as persona non grata. So, persona non grata, he can be deported. Like the case of Inan, wherein every time there is a rally against the government, she participated. Then, he was deported. So, it is a unilateral act of the state. So, I will now discuss first what is an asylum. An asylum, the power of the state to allow an alien sought refuge from the prosecution or persecution to remain within the territory and under its protection. So, that is the power of the state to allow an alien who sought refuge from persecuting or persecution to remain within the territory and under its jurisdiction. Like the latest international news about the brother of Kim Jong-un of North Korea. His brother asked asylum to Malaysia. So, Malaysia given an asylum. Also to Macau. Then also in Malaysia. But he was killed by the two ladies, no? Pinahiran siya ng poison, no? So, that is an asylum. The power of the state to allow an alien who sought refuge from prosecution or persecution. So, that is so, what is the right given if you are granted asylum? If you are given, it is a privilege. So, asylum is a privilege granted by state to allow alien escaping from persecution of his country. Then he enjoys hospitality of the state. Like the case of the U.S., no? Wherein, I forgot the name of that guy, wherein he asked for asylum in Russia because he was charged of espionage, no? I forgot the name, no? It is the latest international news, no? But he escaped in the U.S. because he will be prosecuted for treason and espionage. Then he took asylum to the US, to the Russia, and now he enjoys the hospitality of Russia. Then Russia give him the right. But can the US can conduct surveillance to him? Yes, why not? But he is protected under the state that give an asylum. So remember the meaning of an asylum. How about extradition? So there are two kinds of extradition, no? Bilateral extradition treaty and multilateral extradition treaty. So it will be asked in the bar how you define the meaning of extradition. Extradition is the surrender of an individual by the state wherein he is found to the state under whose laws he is alleged to have committed a crime or have been convicted of a crime. Extradition is effected for the benefit of the state of which the person to be extradited will be surrendered because he is fugitive criminal in the state. So that is a surrender of an individual by the state because he committed a crime under the state that have a treaty. No, for instance, murder. Like Mangkao, no, he was extradited, no, because we have extradition treaty to the US, no. How about deportation? Deportation is the protection of the state in expelling an alien. So deportation is a unilateral act of a state for the protection of a state in expelling an alien or a foreigner because his presence is not conducive to public good. No, I give you an example of the nun that always participated in every rally against the government. So he was deported by the government of the Philippines because his presence is not conducive to public good, and he was persona non grata. There are so many cases because so many students and friends work in the custom and in immigration, wherein foreigners spit on our immigration officers and custom officers. Then they were deported back to their country of origin. No? That is a unilateral act of the state. So remember asylum, remember deportation, and remember extradition. So you must because it is favorite question in the bar. So you better memorize carefully the meaning of asylum, the meaning of extradition, and the meaning of deportation. Okay, we now discuss the doctrine of double criminality. So, last bar examination, I told the barristers that the doctrine of double criminality will come out in the bar examination. Yes, it come out in the bar examination. The examiner in political law and in international law asked the bar examinees, what is the doctrine of double criminality? It was asked last bar examination, 2019, not 2020, because we have no bar examination. If it will be asked in the bar again, how you define the meaning of doctrine of double criminality? The meaning is that the act for which the extraditionis sought to be punished both the requesting and the requested state under what is known the rule of double criminality. Meaning to say that if we ask for the extradition of that Filipino, he committed a crime of murder, same law also in the US of murder. So he can be charged of murder under the, for instance, a Filipino was killed by a Filipino in the US. He can be charged under criminal law of the US. Likewise, he can also be charged under the criminal law of the Philippines. That is the doctrine of double criminality. So both the requesting state and the requested state, they have the same law that punishes a crime committed by the person to be extradited. So that is the meaning of the doctrine of double criminality. So remember, the doctrine of common double criminality, wherein the state that requested that person to be extradited committed their crime, same crime with the state that requested it, then it is called the doctrine of double criminality. Why? He can be charged and tried under the criminal law of the U.S. and he can also be tried and tried under our criminal law. So that is the doctrine of double criminality. Remember, it was us last bar examination. I told the barristers, my bar review is, it will come out in the bar examination. So when they came out from the examination, they said to me, Judge, 90% of your forecast came out in the bar examination. Yes, the doctrine of common double criminality was us in the bar. So, if you want, you attend my lecture on political law and international law in the pre-week review, you know, because I always conducted a pre-week review. Okay, we'll now discuss territories of the states. So, under our constitution, we have what they call archipelago doctrine. No? So, all islands will be so that is archipelagic doctrine. So, it was asked in the bar, what is the basis of the Philippines in claiming Sparkle Island? So, if it will be asked in the bar, what will be your answer? The answer will be, by virtue of the occupation and the exercise of jurisdiction under Presidential Decree number 1596 on June 11, 1978, the Kalayaan Group of Islands becomes part of the territory of the Philippines because it was discovered by Thomas Coloma. It was Thomas Coloma who discovered Sparkle Island, and Thomas Coloma surrendered it to the Philippine government. So, by virtue of Presidential Decree number 1596 on June 11, 1997, Kalayaan Group of Islands, or we call it Sparkle Islands, are now part of the territory of the Philippines. So, it was Thomas Coloma, the owner of a fishing and commercial vessels between 1947 and 46, who discovered the Freedom Land, or we call it Sparkle Island. And then he forever turned over it to the Philippine government. Then President Marcos issued a presidential decree that it is now part of the territory of the Philippines. That is now a political subdivision in Palawan. Okay. We now proceed with the most important topic in international law. The concept of exclusive economic zone under the United Nations Convention on the Law of the Sea. I told my students, the barristers, last bar examination, it will come out in the bar. Yes, it come out in the bar. The concept of exclusive economic zone under the United Nations Convention on the Law of the Sea. It is very, very important. Under the concept of exclusive economic zone of 200 nautical miles under the UN Convention on the Law of the Sea. You know? So we have 200 nautical miles exclusive economic zone. But you know, although we have that, it is the Chinese government who conducted a scientific and maritime research. It is the Chinese government who claim it belonged to the dash one line, no, dash line, no. But that is why we file a case in the international law, in the international court, and we won the case. But unfortunately, our president did not pursue that case. No, we should pursue it because we won on the case. No, so remember, it will come out in the bar again. No, exclusive economic zone under United Nations on Convention of the Law of the Sea. So that is 200 nautical miles. So because the internal waters is only internal or territorial waters is only 212 nautical miles. So there is, aside from 12 nautical miles, that is our internal waters, then another one is the high seas, no? High seas. High seas is different from internal waters, no? The high seas, no? I will discuss it later on, because there is what we call the doctrine of innocent passage. It is favorite question in the bar, the doctrine of innocent passage. Okay, so under the 200 nautical exclusive economic zone, under the United Nations Convention of the Law of the Sea, it is beyond adjacent to the territorial sea, and it will extend up to 200 nautical miles from the baseline. Then it will become the coastal state as an exclusive economic zone. So that is now the Philippine Sea. So if that is our exclusive economic zone, the 200 nautical miles, then what are our rights? Number one, we have the rights to explore and exploit and manage the natural resources, living or non-living, on that 200 nautical miles economic zone. So we have the rights to explore, to exploit, conserve, manage the natural resources, whether living or non-living, in the water adjacent. So that is our right, but it is the Chinese government who utilize that. Second, we have jurisdiction to establish and use artificial islands. So we can establish and use artificial island, but unfortunately it was the Chinese government who used and established an artificial islands. In fact, they have a airport landing area there. Then we can establish and use installations and structures. Unfortunately, it was the Chinese government who have established installations and structures. We can conduct marine scientific research. Unfortunately, it was the Chinese government who conducted the marine scientific research. We can give protection and preservation of the marine environment. Unfortunately, the Chinese government destroyed the marine environment in that Philippine Sea. Although we won under the international court, but unfortunately our president did not pursue. Why? So remember that the 200 nautical miles, our exclusive economic zone, the Chinese government should not have the right. No, they have no right to let our fishermen went away. No, tinaboy nila. They have no right that, because it is our right under the exclusive economic zone of 200 nautical miles under the UN Convention of the Sea. We have jurisdiction to establish and use artificial islands. We can have installation structures. We can conduct marine scientific research. We can give protection and preservation of the marine environment. We have sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living. Unfortunately, it was the Chinese government. So, but now, I heard that the Chinese government wanted that we have a joint marine exploration of our 200 nautical miles. Can we do that? Yes, if we have no resources, we have no money, we can do that, but the percentage must be 60-40, no? Mas mataas tayo because we own that. The Chinese don't own that, no? That is, it belongs to our 200 nautical miles economic zone under the UN, United Nations Convention of the Law of the Sea. The Chinese have no rights on that. They cannot even conduct marine and scientific research of the Philippine Sea because of that under the UN Convention of the Law of the Sea. Next, what do you mean by territorial sea and high seas? It was asked in the bar examination. If it will be asked in the bar examination, how you will define? How you define territorial sea and high seas? It was asked in the bar examination. So, a territorial sea or internal sea is a 12 nautical miles. No? So, that is from our baseline, that is 12 nautical miles. So, what is the width? No? There is no yet a concurrence of the United Nations, but they use the Article 3 of 1983, the Law of the Sea, the 3-mile rule. No? Then there is now what we call 2-mile rule found under Article 3 of the 1983 Laws of the Sea. How about high seas? High seas, Article 1 of Geneva Convention of High Seas. All parts of the sea that are not intended in territorial sea are now considered, or internal sea are now considered high seas. So beyond the 12 nautical miles, it is now considered as high seas. High seas. So if it is a high seas, there are 6 freedoms. If it is not an internal or territorial sea, if it is a high seas, there is 6 freedoms. Number 1, freedom of navigation. So any vessel can navigate. Second, freedom over flight. Now, any airplanes can pass by because it is an international water or high seas. Third, there is a freedom of fishing. No, you can fish there because it is an international water. Number 4, freedom to lay submarine cables and pipelines. No, so you can lay submarine cables and pipelines. Then the third one, freedom to construct artificial islands and structures. And the sixth one is freedom of scientific research. So, if it is an international water or high seas, under Article 1 of the Geneva Convention of the High Seas, then there are 6 freedoms. No? Freedom of navigation, freedom of flight, freedom of fishing, freedom to lay submarine cables and pipelines, freedom to construct artificial islands, and freedom of scientific research. So remember, compañeros, compañeras, what is a territorial sea or internal sea, what is high seas or international sea, and what are the 6 freedom under international sea or high seas. No? So that is under international law. Okay. We now proceed with treaties and executive agreements. It was asked in the bar, is a treaty and executive agreement the same? The answer is no. So, how you define a treaty? A treaty may be defined as a formal agreement, usually in writing, is entered into by states or entities possessing the treaty making capacity for the purpose of regulating their mutual relations under the law of the nations. It usually requires ratification by the contracting party. So that is the meaning of a treaty. A treaty may be defined as a formal agreement, usually in writing. It must be in writing, which is entered into by the states or entities possessing the treaty-making capacity for the purpose of regulating mutual relation under the law of nation. It usually requires ratification by the contracting party. Under our Constitution, if we enter into a treaty, then there is what we call ratification. It must be ratified by Congress, not the upper house and lower house. It should be the upper house only. 2/3 vote. No? Ratification of there must be a ratification of a treaty by 2/3 vote. So when I lectured international law before lawyers, judges, and prosecutors, they asked me, whether or not the president can abrogate, terminate, invalidate a treaty. So every time that I lectured before lawyers, judges, they always ask me, Judge Pampilo, can the president unilaterally abrogate, terminate, invalidate a treaty? So we discuss first a treaty. A treaty, before it will become valid, it must be ratified. So who will ratify our treaty? It is the Senate by a vote of 2/3. How about executive agreement? What is an executive agreement? Executive agreement is an agreement usually entered into by the executive department, by the president or its counterpart, and intended to implement or clarify provisions of a treaty. It does not require ratification under our Constitution. So, if it is an executive agreement, there is a question now in the Supreme Court whether or not an executive agreement entered by Noynoy Aquino must be subject to ratification. The answer is no, because an executive agreement it does not require a ratification under our law. Only treaty. A treaty must be ratified by Congress, particularly the Senate. No? 2/3 vote. So, if it will be asked again, what is a treaty and what is an executive agreement, and how you distinguish between a treaty from an executive agreement, the answer is this. A treaty is defined as a formal agreement, usually in writing, which is entered into by states or entities possessing the treaty-making capacity for the purpose of regulating their mutual relations under the law of nations. It usually requires ratification by the contracting party, while an executive agreement is usually entered by the executive department of its counterpart. It's simply intended to implement or clarify the provision of a treaty. It does not require ratification under our Constitution. The distinction, however, is purely municipal and has no internal significance. Mami?
Tubig?
Pahingi mo ng tubig, mami. Diretso ng lecture ko, umabot na ako ng 1 hour and 31 minutes.
Okay.
Water muna.
30 minutes na lang.
De, 28 na lang. 6:32 na eh. Saka patapos na rin ako. Binilis ako. So, para awal kompanyero, para future kompanyeros at kompanyeras, iinom na ako tubig.
Relax.
Mahaba-haba na lecture ko. So, but as I've said, the decision, however, is purely municipal. and has no international significance. From the standpoint of international law, treaties and executive agreement are alike in both. It constitutes equality binding obligation of a nation. So, under international law, executive agreements and treaties are the same. They have equal binding obligation upon the nations who entered it. No? So, remember, the meaning of a treaty, the meaning of an executive agreement. A treaty is a formal agreement, usually in writing. Under it, it's subject to ratification by Congress, 2/3 vote. While executive agreement is usually entered into by the executive department. So it is the president. Sometimes this president will delegate it. If it is military executive agreement, the president will delegate it to the his cabinet secretary, the national defense, no? So on and so forth. So that is an executive agreement. There is now a pending case before the Supreme Court whether or not executive agreement is subject to ratification. The answer is no. So remember, treaty and executive agreement. Can the Supreme Court acquires jurisdiction to declare a treaty and executive agreement unconstitutional? The answer is yes. The Supreme Court have the authority to decide whether or not a treaty or an executive agreement is constitutional. So, the Supreme Court can declare a treaty to be unconstitutional or an executive agreement to be unconstitutional. So remember, a treaty and executive agreement, and how a treaty and executive agreement distinguish each other. It might be asked in the bar examination. Then, in the case of Pimentel versus Romulo, GR number 158088, July 6, 2005 decision of the Supreme Court. When a treaty is signed by the official representative of a state, that this means that it's already bound by the provision of a treaty. It was asked in the bar. That is the issue raised in the case of Pimentel versus Romulo, GR number 158088, July 6, 2005. So, the question, the issue here is, when a treaty is signed by an official representative of a state, does this mean that it's already bound by the provision of a treaty? If it will be asked in the bar again, what will be your answer? You cite the case of Pimentel versus Romulo. The Supreme Court ruled, no. No, in the case of Pimentel versus Romulo, GR number 158088, July 6, 2005, the Supreme Court ruled that the signature does not signify the final consent of the state to the treaty. It is the ratification that binds the state to the provision thereof. So remember, if it is already signed, for instance, by the representative of the Philippines and the representative of the U.S., then it is already binding. The answer is no, subject to ratification. So who will ratify under our Constitution? It is Congress who will ratify. It is the Senate by a vote of 2/3. So remember, the case of Pimentel versus Romulo, wherein the Supreme Court ruled, when a treaty is signed by an official representative of a state, does this mean that it's only bound by the provision of a treaty? The answer is no. Then you cite the case of Pimentel versus Romulo, GR number 158088, July 6, 2005. Because in order to bind the state, there must be first ratification. Remember, future compañeros and compañeras, there must be ratification in order that it will be binding both parties. And who will ratify it? It is the Senate by a vote of 2/3. 2/3 vote of the Senate. There are 24 senators in the Senate. What is the 2/3 vote of the Senate? So, 2/3 vote in the Senate. 6, 6, 18, 24, 12, no? 2/3. So, what is the 2/3 in 24? So, 8 siguro, no? 16, yeah, 16. So, it is 16 votes, no? 16 votes of the Senate. So, remember that in order that a treaty become unofficial, then it must be ratified. Okay. Invalidation of a treaty or termination of a treaty. So, the President Duterte abrogate, terminate, invalidate our treaty with the U.S. But unilaterally, meaning to say, without the consent of Congress, without the consent of the Senate. Okay, can our President abrogate, invalidate, terminate a valid treaty? So, I will discuss first the different grounds for invalidation or termination of a treaty. We must revisit Article 48 up to Article 53 of the Vienna Convention of Treaties. Remember, Article 48, 49, 50, 51, 52 to 53 of the Vienna Convention on Treaties. So, under Article 48, 49, 50, 51, 52, 53 of the Vienna Convention on Treaties, it enumerated the grounds wherein we can invalidate, terminate, abrogate of a treaty. So, what is that? Number 1, same grounds of invalidation in a contract. So, according to Article 48, 49, 50, 51, 52, 53 of the Vienna Convention of Treaties, the usual grounds for invalidation, termination, abrogation of a treaty is the same with contracts. Number 1, there is an error. So, if there is an error, then it is a ground for invalidation, termination, abrogation of a contract. Error of facts. Second, there is fraud. Third, there is corruption. No? Binayaran pala to enter. No? Then there is juris, tinakot. So, under Article 48 up to Article 53 of the Vienna Convention on Treaties, same with invalidation of contracts. In order to invalidate or terminate a treaty, number 1, there is an error of facts. Second, there is fraud. Third, there is corruption. Then, the fourth one is juris. Then, another ground to invalidate is if there is a conflict between peremptory norms of general law on public international law or jus cogens. No? So, if there is a conflict between the two, then it is also a legal ground for invalidation of our invalid treaty. Is when President Duterte invalidate a treaty that we entered with United States of America. What grounds he used? Is it an error of fact? Oh, there is none. There is fraud? There is none. Is there corruption? None. Is there juris? None. So, all of the above, none. So, what will be the best grounds that our President can abrogate, terminate, invalidate a valid treaty because the grounds that cited under Article 48, 49, 50, 51, 52, 53 of the Vienna Convention on Treaties, hindi siya pasok, no? There is no error of facts, there is no fraud, there is no corruption, there is no juris. So we'll proceed with other. Can you still remember rebus sic instantibus? So it might be asked in the bar examination. I will discuss extensively rebus sic instantibus. No? You still remember pacta sunt servanda, no? But in invalidation, termination of a valid treaty, aside from error of facts, aside from fraud, corruption, or juris, pacta sunt servanda is also, rebus sic instantibus is also one of the ground to invalidate, terminate, abrogate a valid treaty entered by one state to another state. We will discuss rebus sic instantibus because I believe it will come out in the bar examination. Okay. A treaty may be terminated or suspended according to the terms of the treaty or with the consent of the parties. So, is there a terms in the treaty wherein our president can terminate or suspend the treaty? So, in order that the treaty will be terminated or suspended, there must be a terms of a treaty. That is one also of the grounds wherein the president can terminate, invalidate, and abrogate a treaty. So, that is another one. Number 5, no? There must be a term wherein a treaty can be terminated. So, for me, there is none in this case. Number 6, with the consent of the parties, is the U.S. consented to the abrogation, to the termination, and invalidation of our president of the existing treaty between the Philippines and the U.S.? None. Trump did not consent to the termination, abrogation, invalidation of our treaty. Next, the treaty must be with a definite period. Then if there is a definite period, for instance, only 5 years, then it will expire. I believe there is no the period that the treaty, the life of the treaty that we entered into with the U.S., I think it is not yet within that period. The period did not expire yet. So, the president have no authority to abrogate, terminate, invalidate our treaty because the period not yet expired. So, if the treaty, for instance, 10 years, the life of the treaty is 10 years. No? So, if after 10 years, then it expires, then we can terminate, abrogate, and invalidate a treaty because it expires. Then another one, it may also be terminated if or invalidated when the purpose of the treaty has already been achieved. So, not yet, no? Because we have to protect our territory, no? So, another one, it may also be if the purpose of the treaty already achieved. I believe there is no achievement yet. So that is not a ground for termination. So, how about rebus sic stantibus. The last one. So, I believe the President can abrogate, terminate, invalidate our treaty, but subject to ratification with Congress under the doctrine of rebus sic stantibus. So what is a rebus sic stantibus? So there are other modes in terminating or suspending, abrogating a treaty. Number one, material breach. I believe there is no material breach between the Philippines and the U.S. Third, impossibility of performance. So no, there is no impossibility of performance. And the last one is rebus sic stantibus, meaning to say change of fundamental conditions. So I believe it should be rebus sic stantibus, change of the fundamental conditions, in order that our President can validly terminate, abrogate, invalidate a valid treaty between the Philippines and the U.S. So remember, there is error of facts, fraud, corruption, juries, no? Then another one, the purpose already achieved, the treaty, there is a period or life of the treaty already expired, and that the purpose of the treaty already achieved, so it can be terminated. But the other modes of terminating are as follows. Number one, there is a material breach. Second, impossibility of performance and change of the fundamental conditions. So, impossibility of performance and change of fundamental conditions. This is what they call rebus sic stantibus. So remember, future compañeros and compañeras, aside from there are lawyers, judges, and prosecutors who attended our online lectures. No, I saw them. No, kumaway nga mga judges, saka prosecutors, saka lawyers. They were my friends. No, they're waving their hands. No, I saw them. No, so thank you, judges. Thank you, prosecutors and lawyers, for attending my lecture. So remember the grounds, the valid grounds for termination and invalidation of a valid treaty. Okay, my last lecture will be the state responsibility and the laws of war. So, what is the state responsibility to a wrongful act, or we call it internationally wrongful act? And what is the doctrine of state responsibility? So this will be my last topic on international law. 7 o'clock na. So, if it will be asked in the bar examination, what do you mean by doctrine of state responsibility? Then, what do you mean by international wrongful act? So, if it will be asked again in the bar examination, what will be your answer? What do you mean by doctrine of state responsibility and the doctrine of international wrongful act? This will be your answer. And under international law, a state is responsible for internationally wrongful acts. When an injury is inflicted to an alien within state territory, then there is a need to determine whether the state can be held responsible for it. One of the principles most strongly held by the state is that if the state violates the customary law, no? If the state violates customary laws of under international law or under a treaty obligation, then it commits an internationally wrongful act. So, if the state act violates the international customary rule or international law or a treaty obligation, then the state committed an internationally wrongful act. There is an internationally wrongful act of state when the conduct consisting of an action or omission is attributable to the state under international law and constitute a breach of international organization of the state. So, remember the meaning of internationally wrongful act. There is an internationally wrongful act of the state when the conduct consists of an action or omission. It is attributable to the state under international law and constitute the breach of the state under international law. Then it constitutes the breach of international organization of the state. Then it will be called internationally wrongful act. So, compañeros, future compañeras, I will summarize my lecture. So, I have still 5 minutes to summarize my lecture. So, if a question will be asked in the bar examination, is international law a true law or not? You must qualify your answer. It is not a true law and it is a true law. So, remember that. In case of conflict between municipal law and international law, who will prevail? Remember the case of Ichong versus Ichanova. Then the case of Gonzales and the case of Garcia. No? Those are the cases that involves our domestic law in conflict with international law. No? But according to the Supreme Court, if there is really a conflict between municipal law and international law, courts are organ of the municipal law, then we, judges, must always sustain that municipal law will prevail over international law. That is the case of Ichong, then the case of Ichanova, Gonzales, and the case of Garcia. No? Then remember the two theories, now the monist theory and the dualist theory. So remember those theory, the monist theory and the dualist theory. Then very important in the restrictive theory, that is the restrictive or newer theory, and the classical or absolute theory. But the most important, remember, future compañeros and compañeras, you must study the 220 nautical mile exclusive economic zone, that is 200 nautical miles under the United Nations of the law of the sea. No? Because if that is our exclusive exclusive 200 nautical miles economic zone, we have every rights, not the China. That is why it will be asked again in your bar examination. Then remember the doctrine of innocent passage. Now, the doctrine of innocence passage. Remember what is internal water or territorial water and water high seas or international water. Then treaties. Remember treaties. Remember deportation. Remember deportation, asylum, and treaties. Then remember what are the grounds for invalidation, termination of a valid treaty. Then the last question that always asked by judges, lawyers, and prosecutors. Judge, you know very well in international law, can our president unilaterally abrogate, terminate, invalidate a valid contract? My answer, my humble answer is no. Until now, there is no yet jurisprudence of matter, but I believe my answer is correct. But that is only my legal opinion, because I believe President Duterte cannot unilaterally abrogate, terminate, invalidate a valid treaty. It must be subjected to ratification by the Senate. In order that a treaty become valid, there must be a ratification. And who will ratify? It is the Senate. So, if it is, in order to be valid, it will be ratified by the Senate, 2/3 vote. Then, if it will be invalidate, same, no? Subject to the ratification of the Senate by a vote of 2/3. Okay? That's end of my lecture. Hopefully, that I was able to help you in order to top the bar, because last bar examination, my student topped the bar, number 2. I produced so many bar top answers. So, thank you. Thank you also, I think, and thanks my colleagues who are judges, also prosecutors and lawyers. Thank you very much. God bless you. Future compañeros and compañeras, thank you very much. Thank you.